Honourable Senators, I rise to speak to Bill S4, an Act to amend the Criminal Code. Over the past 2 years, Canada's criminal justice system, like nearly every facet of society, had to adapt quickly and substantially to function during a time of enforced social distancing and a myriad of other challenges posed by COVID-19. When we needed to put our modern communications technology to the test, most organizations found ways to advance efficiency, functionality, and convenience that will certainly endure past the pandemic. Having practiced law for many years and being a member of the Legal and Constitutional Affairs Committee during our 18-month comprehensive study on court delays, I am acutely aware of the problem of excessive backlogs and the need to innovate and modernize our criminal justice system. However, as the justice system grapples with how to change in a digital age, the integrity of Canada's court process must remain paramount and should never be compromised for the sake of expediency. Bill S4 permits the continuation of many electronic processes that began during the initial COVID lockdowns. However, it also extends permanency to the option of virtual appearances before we have enough data and experience to assess the impact. I have specific apprehension with the proposal to allow an accused to appear and testify at their criminal trials by video. Under this bill, all criminal trials for both summary and indictable offences, and regardless of the severity of the offence, could be conducted this way. What I find most concerning is the impact this could have on the judge's ability to assess the credibility of the accused. Those of us who have spent extensive time in a courtroom know this is a critical factor in almost all criminal trials. While we are a long way from fully understanding the total impact of virtualizing meetings, conversations, and proceedings that have always been face-to-face, the data we do have suggests cause for concern. In a 2017 U.S. Government Accountability Office report on immigration courts, judges in 50% of the surveyed courts identified instances where they had changed credibility assessments made during a video hearing after holding a subsequent in-person hearing. In one instance, an immigration judge failed to identify a respondent's cognitive disability over video, which the judge said was, quote, clearly evident when the respondent appeared in person. In another case, the poor audio quality led to a misunderstanding of the facts of the case, which was not clarified until the respondent was able to appear in person. The change in the credibility assessment ultimately changed the judge's decision. Another study by Swedish psychology professors Landström, Ask, and Somar found a substantial difference in perceived credibility between video testimony and in-person testimony. They described the, quote, vividness effect, whereby live testimony, due to its face-to-face immediacy, is, quote, more emotionally interesting and proximate in a sensory, temporal, and spatial way, is generally perceived by observers as more credible, and is better remembered, quote. In an article in the Tulane Law Review, law professor Anne Bowen-Poulen points to a body of literature suggesting video conferencing may have a negative impact on the way the defendant is perceived by those in court, as well as the representation the defendant receives. She further notes, quote, when decision-makers interact with the defendant through the barrier of technology, they are likely to be less sensitive to the impact of negative decisions on the defendant, quote. In committee, Senator Pate drew our attention to the research done at the University of Surrey in England, which studied the merits of electronic proceedings, and found that defendants were more likely to be jailed following video hearings, and suspects whose cases were dealt with remotely were less likely to have legal representation. Witnesses at our legal committee raised additional concerns with video conferencing. Emily Coyle, the executive director of the Canadian Association of Elizabeth Fry Societies and the daughter of Senator Coyle, testified about stigma against an accused appearing by video from prison and often in prison clothing, rather than, for example, a suit that their family had given them, quote. This can cement in the trier of fact's mind, in this case the judge, that someone being seen in a jail setting during a trial should perhaps remain in jail and potentially give a bias to a guilty verdict. As Ms. Coyle expanded, quote, society assigns judgment to people who are in prison without understanding their background. Because we have this idea that people in prison are bad, we put bad people in prison, that judgment that we cast upon people who are in prison would lead potentially to an outcome in trial that would not necessarily have been the outcome had that person not been in prison, quote. Mark Knox from the Canadian Council of Criminal Defence Lawyers testified about the slippery slope and the, quote, movement away from the humanity, the decorum, all of these factors that are associated with an in-court trial, quote. He cautioned against rushing to implement these supposed modernizations, quote, for efficiency's sake, in a rush, quote. When I asked him about an amendment to remove the ability to have trials by video while leaving the other proceedings as proposed, he responded, quote, I agree with you. There are places we could start to see how it works, quote. Our committee also heard from Ms. Eva Tash-Green from Nunavut Legal Aid. She told us that 24 out of 25 communities in Nunavut do not have technology to do a video conference in court. Coincidentally, early in her testimony, her face froze with the network bandwidth is low message on the screen. She was in a legal aid office with comparatively high connectivity, and even her ability to communicate with our committee was impeded. She then had to do the rest of her testimony using only audio and turn off video. When I asked for her input on this amendment, she agreed, suggesting that we hold off on making video conferencing available for trials and start with, quote, proceedings that have lesser jeopardy, quote. She added, quote, I'm very concerned about the possibility of trials proceeding with an accused who is, of course, the person with the most at stake, being potentially cut out of the proceeding by the technology breaking down, quote. Colleagues, even the best technology has its limitations. Look no further than this very chamber and the limitations a hybrid parliament has placed on our ability to do our work. We often run into connectivity issues. This is on Parliament Hill in Canada's capital city with state-of-the-art technology and a sizable IT department. Sometimes a senator who has lost connection is in a fairly remote location, but there are many other times we lose connection with a senator from their home office in our largest cities, or even worse, from their office on Parliament Hill. One can only imagine the substantial issues as the courts attempt to rely on video technology from northern, rural, and remote locations. For example, it is no surprise that there are major technological gaps in northern Saskatchewan, but there are courtrooms in Regina that still don't have Wi-Fi. And we are not talking about relying on a consistent connection for a 15-minute Zoom speech. This could potentially be several hours of accused testimony. While carefully considering this amendment, I consulted with several people who work in courtrooms and conduct criminal proceedings every day, including defense attorneys and judges from Provincial Court and Queen's Bench Court. I spoke to judges who were initially enthusiastic about using video technology for criminal trials, but who have completely changed their minds after seeing it in practice for 2 years. They believe strongly in the merits of non-trial efficiencies, such as adjournments by email, video for guilty pleas, etc. Yet they have now seen firsthand that far too much is lost in conducting a trial this way, and the stakes are simply too high. One judge I spoke with made an excellent point. A courtroom is a serious place, and everything inside it, from the well-appointed interiors and the elevated dais, to the judges' robes, to the requirement to address judges as Your Honor and My Lord. It evokes a sense of seriousness, somberness, respect. This is crucial so that those testifying are more likely to feel bound by their oath and respect the judge's decisions. There is no comparison between putting your hand on a Bible in a courtroom full of people, including possibly a victim, your accuser, reporters, your family, versus taking an oath by video. When an accused is sitting at home on his couch or in jail, not only is his charter right to properly consult with his lawyer in jeopardy, but the gravity of the situation is unquestionably diminished. There is serious concern that over time there will be a major deterioration of respect for the court and the trial process to the profound detriment of all. Judges relayed troubling examples from the past 2 years, such as an accused testifying from his couch who actually swore at the judge, a witness testifying from his shower during a criminal trial, and most disturbingly, a domestic violence victim testifying from home with her abusive spouse in the next room. In these cases, testimony by video robbed the judges of any control over the environment. In many sexual assault cases, the dynamic is very often he said, she said. If an accused appears by video, the judge often loses the ability to assess demeanor and to even examine any interplay between the accused and the accuser in the courtroom. The impact of this should not be underestimated. Trial judges are trained how to assess credibility of witnesses, including a defendant in a courtroom, and that assessment is considered extremely valuable. In fact, findings of credibility made by a trial judge are not to be overturned by an appeals court other than in very rare circumstances. This is because trial judges can assess credibility right in front of them, not in a remote way. When I introduced my amendment to remove video from criminal trials at Legal Committee, Senator Campbell, stating that he had testified at many trials, reminded the committee, quote, A trial is a big deal, especially if you are the one who is on trial. He further stated, quote, "I don't think you can discount credibility. I believe that credibility is important in every single case. I will support this amendment. I don't believe it is a step back. I believe it is protecting Canadians from a technology that we have not perfected yet," quote. Then Senator White, when he spoke in support of this amendment, questioned whether the impact on victims and the importance of their ability to fully participate in a trial had been adequately considered in this bill. He said, quote, "I think we need to walk before we run. I'm not sure that in the last 2 years that we have proven that we walked very well," quote. Rather than adopting the very reasonable amendments that Senator Carignan and I put forward, our legal committee decided to append several observations reiterating the very serious concerns of our witnesses. Concerns about inequitable access to technology, interpretation, privacy, security, confidentiality, the ability of the accused to confer with defense counsel. One observation went so far as to say witnesses, quote, "raised concerns that these rights were not being sufficiently respected," quote. Honourable Senators, this is not observation material. This is amendment material. If the Trudeau government is willing to procrastinate on and ignore mandatory parliamentary reviews written directly into legislation, what hope does a mere observation have in catching the government's attention? With respect to the amendment I am bringing forward today, some have argued that there is minimal risk, as all parties must consent. However, many witnesses raised concern with the very concept of consent in this context, especially given the profound power imbalance that could impact an accused's ability to make informed, free decisions. Ms. Coyle from the Elizabeth Fry Society said that an accused may be told they will face delayed timeframes if they don't proceed virtually, and if they are not made keenly aware of what is at stake by foregoing a traditional day in court, can we honestly consider that a free choice? Just think about the charter challenges that could arise when an accused has been told by their counsel that this is their only option, or they will spend less time in jail, or save them money. It is easy to foresee an accused agreeing, then getting convicted, and later challenging the decision based on a violation of their charter rights. Some maintain this is a non-issue, as the judge can simply decide not to sign off on this. On paper, there may be no reason to not proceed by video for a particular trial. A judge may later deem unforeseen connectivity issues as minor, but will never truly know what was missed. There may even be circumstances where the virtual trial appeared to be a success. However, a judge is a human being, and the research is clear. There are intangible, qualitative elements that do not come through in a virtual setting that will likely result in an incomplete or even inaccurate assessment of the accused, even for the most experienced and well-intentioned judges. To be clear, the amendment I am proposing will not remove all video capability for the accused in criminal proceedings. In fact, my amendment would allow the accused to use video technology for the many other types of criminal court proceedings and appearances permitted by Bill S4, including bail, preliminary inquiries, pleas, and sentencing. My proposal is simply to eliminate this option for trials and start with these matters of less jeopardy. This is very much a cautious compromise proposal. As the judges I spoke with emphasized, the provision to operate this way in an emergency already exists in the criminal code. If there is another lockdown, they can use video conferencing as necessary. Their concern was that Bill S4 suggests that trial by video is the default or preferred method going forward, and the evidence is clear. Making this the default approach comes at a tremendous price. I will conclude with a quote from the Barreau du Québec, who recommended to our legal committee that all testimonial evidence should be excluded from video conferencing, quote. First of all, the lawyers in this group work on the ground every day, and they state, quote, in an in-person trial, a simple note passed to counsel, or even a glance shot at them by the judge or witness, is likely to change their approach or strategy and affect the outcome of the trial, quote. They further state that under this bill, quote, remote trials become the rule rather than the exception, quote. Honourable Senators, I ask for your support on this compromise amendment. I move that Bill S4 be not now read a third time, but that it be amended in Clause 46A on page 21 by deleting lines 4 to 16, B on page 22 by replacing line 5 with the following, quote, means other than a trial or a summary conviction or indictable offence, the court may allow the accused or offender to, quote. I ask for your support. Thank you.